number 96, American Economy versus the State of New York. Counsel?
Thank you. Stephen Wu for the State of New York. I'd like to reserve 2 minutes for rebuttal.
You may, Mr. Wu.
One of the unique protections provided by workers' compensation is the long-term financial commitment that it requires insurance carriers to make to injured workers.
Counsel, how do the employers benefit? What is the savings that they get as a result of the amendment and the closure of the fund?
There's an immediate cost savings in the form of getting rid of what has ballooned to be a $300 million annual assessment against employers. That's sort of the immediate cost savings at issue here. And there's a longer-term cost savings from what are anticipated to be increased efficiencies from having insurance carriers retain these liabilities rather than transfer them to a third party, which is the fund.
Is the first one offset by increased premiums?
To some extent, in the short term, it may be offset by increased premiums, but that gets me to the longer-term benefits of this. And there are a couple of benefits here to cost savings. The one is that carriers that retain these liabilities can use their existing apparatus to adjudicate claims, to evaluate them, and basically to administer these workers' compensation claims going forward. Before, there were substantial costs in having a separate party, which is the Fund for Reopened Cases, assume these claims often many years after the date of the injury.
And in fact, there was a lot of litigation over that whole system, right?
That's correct, and that's sort of the second big cost savings here, is that the very process of transferring claims to the Reopened Cases Fund was a complex and costly one. It was one that involved a great deal of administrative litigation, as well as litigation to the third department and even to this
So
court.
this is where I'm unclear. So who was bearing the cost of that? Aren't all of these costs either through surcharges or a pass-through? Who actually was paying for that?
The immediate assessments were levied against the insurance carriers, but under 151 of the workers' compensation law, they were then allowed, the carriers were allowed to surcharge the employers and therefore collect some, though necessarily not all, of the assessments that had been levied
So
against
what's the
them.
windfall to the carriers that was referenced as a basis for the amendment?
There are a couple of answers to that, and I think the clearest answer comes from the immediate impetus for the closure of this fund, which was the rapid escalation of the costs that were imposed on employers here. What that represented was an increased utilization of the fund by insurance carriers that exceeded the assumptions that had been in place when premiums were first imposed. In other words, carriers had collected premium in the years prior to the closure on the assumption that they would retain a larger amount of liability than they in fact retained when the time came to pay those claims. And the flip side to that is that employers were basically required to pay twice. They paid premiums so that the carriers could retain certain liabilities. And then when several years later the carriers transferred basically triple that amount of liability to the fund, employers again had to pay assessments to the fund to manage those liabilities. And that is in part the premium windfall that the governor's memorandum was referring to as a basis for saying that the cost of this would be somewhat
So when you
defrayed.
use a windfall, it's almost as if it's unexpected. What was unexpected about that?
What was unexpected was what is always unexpected in these cases. When there's a change in the way that the workers' compensation system operates different from what had historically occurred. And that change here was the dramatic increase in utilization. And just to give you a sense of the numbers, in 2006, the assessments levied against employers was under $100 million, and that had roughly been the figure for several years. Only 6 years later, by the end of 2012, that figure had ballooned to over $300 million. And as a result of that, the legislature, supported, I should say, by the insurance industry and by employers, decided to close the fund.
Can I ask you a question about the meaning of a statement in the July 2013 DFS decision that reads, "It's not practical or feasible to quantify the effect of the fund closure will have, if any, on the experience of policies that are currently in effect. To the extent that such experience is adversely affected by the RCF closure, the adverse experience will be reviewed as part of future rate filings." What is DFS doing, if anything, with regard to RCF closure-related expenses and future rate adjustments?
Well, I think that is basically a statement that they are going to be seeing what the anticipated effects of this closure are going to be in a broader scale.
And will adjust premiums upward to compensate the insurers for losses out of the RCF fund, or no?
Yes, they will. There will be premium increases, and there have been premium increases to account for the fact that insurers are now required to retain those liabilities and to pay them basically out of their own pocket.
And does that apply to past liabilities or no?
Well, it does not in a technical actuarial sense, which is that DFS does not approve rate increases going back in time. It only increases rates going forward.
But will the forward rates account for losses that arise from the RCF fund closure prior to 2014?
They will not, again, as a technical matter, but this is not unique to premiums for the purposes of the closure of the fund here. I mean, premiums never look backward, even if there are unanticipated statutory changes. And the broader context here is that that is routine in the workers' compensation law. There are always going to be changes to the benefits to employees, to the costs on carriers, and to the
So you
burdens
mean
on
if in the
employers.
past, so you mean that if in the past, whatever premiums had been set in the past, as it turns out, don't actually cover the expenses, carriers have to pay for that anyway, because the premiums were the premiums that were set.
That's correct. And my
So
point
they may have
here,
benefited in the past.
well, and that's my point here, is that that is part of the expectation of all the participants in the system, that there will be changes, and that premium may or may not account for them. And as you just referenced,
One of
sometimes...
the, excuse me, one of the things in the approval memorandum that was sent over with the legislation is a statement that the premiums the insurance carriers charged already covered the liability. Do you concede that that statement in the approval memorandum, I think it was from the governor's office, was incorrect?
I do not, and part of the answer is the answer that I gave to Judge Rivera about how the increased usage of the fund actually made past collected premiums excessive, based on the assumption that carriers would retain a larger set of liability.
Well, are there other justifications, hypothetical justifications for any possible retroactive impact of the law that we can point to, then assuming that those premiums were not charged to cover this liability?
There are other justifications, and they're not hypothetical. They were explicit in the legislative history. And the two main ones were, first, to reduce a burden on employers. And that burden reduction could be achieved most immediately by cutting off the fund to new applications going forward, instead of deferring the effect of that closure until post-enactment dates of injury.
The burden being this 300 million as opposed to 100 million? Is that what
That's
you mean?
correct. That's correct. And the second was another rationale that was supported both by the industry and by employers, which is that the fund had outlived its original purpose. You know, when the fund was created in 1933, it was intended to be a one-time adjustment for a very small number of cases. I think 20 cases were filed in the first year, growing to only 100 in 1936. By 2012 and 2013, thousands of claims were being adjudicated at the cost of hundreds of millions of dollars. And importantly, the types of claims that were being adjudicated were also substantially different. The fund was created, as its name suggests, for claims that unexpectedly would reopen. But the history here shows that the types of claims being transferred were increasingly shifting to cases where there were foreseeable ongoing medical costs that technically qualified for transfer to the fund because indemnity payments for lost wages had been settled 7 years before. And as a result, the fund was no longer dealing with cases where carriers could not predict the costs going forward that had unexpectedly reopened.
Let me just go a little briefly to the Article 1, Section 16 argument, or Section 18 argument, the New York State Constitution that you made. Did you raise the issue below?
This is the argument about whether the workers' compensation law is affected.
Is included in the New York State Constitution, yeah.
Yeah, I don't recall if we made that argument specifically below. We are not principally relying on that argument as a basis for saying that the constitutional arguments here fail. I think, if I could just finish this one thought, I think the basic arguments on the constitutional claims are that they're premised on two fundamental mistakes. The first is that there is no legitimate justification at all for the closure of the fund. And you know, what I've been arguing so far is that there is a legitimate justification here articulated in the legislative history. And the second is a fundamental mischaracterization by the carriers about the nature of their initial liability. I think a core part of their argument is that when they entered into these contracts, the contracts themselves excluded liability for what they're calling claims in reopened cases. But that is flatly incorrect. What the Reopened Cases Fund did was to provide a mechanism for relieving certain liabilities by carriers as they arose in the future from reopened cases. It was not a redefinition of their initial liability. And we can tell this in part because what triggered the fund's application was an application by the carrier to, as the statute says, transfer their liability to the fund to handle. Because of that, the basic starting premise is that insurance carriers had this liability, and the fund's removal only changed their relief going forward.
Thank you, counsel. Counsel?
May it please the court, I'm Seth Waxman for the respondents. I think maybe I'll start by addressing the two concluding points that my friend raised, one of which is that we're wrong in our core argument that this legislation, this amendment imposes retroactive liability, has retroactive effect, and secondly, that our argument is that there's no legitimate justification to close the fund. I'll start with the first one first and hope that I get around to the second. The 2013 amendment makes insurers liable for a category of coverage, that is reopened cases described in Section 25A of the Workers' Compensation Law, that were not included in the earlier state-approved contracts and were not covered by premiums that insurers were permitted to change. I don't think there's any dispute about this, but let me just point the court to the places in the record that establishes that. The contract, at page 504 of the record, you'll see a sample state-approved contract, and the contracts.
Counselor, if we accept this argument, when could any changes ever be made to allocating who pays what in workers' compensation cases?
So, Your Honor, there are two
Retroactive.
questions embedded here. If the first question is the law retroactive or isn't it? And I understand Your Honor's question to be, let's assume that it is.
Right.
Under what circumstances can the legislature enact laws that are retroactive? There are many instances in which, and the Supreme Court and this court has been clear, that retroactive legislation is not in and of itself unconstitutional. It may be constitutional if it meets the specified tests that this court and the U.S. Supreme Court has established for scrutiny under the three provisions of the Constitution. I'll say the United States Constitution, two of which exist in the New York State Constitution, that are sensitive to retroactive legislation. So, for example, under the Contracts Clause, a state may impair the obligations, contractual obligations, but only to the extent that the regulation is, quote, reasonable and necessary to serve an important public purpose. And as this court's decision in the Health Industries Association versus Hartnett and Moore versus Metropolitan Insurance.
Let me jump in here on Hartnett, because I think it goes to the heart of your argument, and one of the things I've struggled with it. It seems that you have a retroactive application of the law that just says it's going to result in $62 million in unfunded liability, which says to me that you have a contract that says that you are required to cover these particular losses. And I think you'd agree with that.
No, Judge Fahey, I actually don't agree.
Okay, let me finish my thought then.
Okay.
All right. Because the way I read it, it says if you've got an unfunded liability and your contract, which I'm looking at page 264 from the sample contract, says workers' compensation law means blah, 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 and it seems to specifically lay out your obligation to cover any loss under the workers' compensation law and or any amendments to the workers' compensation law. So if there's no liability, you would simply disclaim. If there is liability, then this liability is funded, and we're talking about a loss of profit, not necessarily the creation of a new liability. Hartnett is a maternity case, and that I think is a question of the creation of a new liability. And I think that's why I want to explain this conflict for me, if you could.
Right. So there isn't a conflict because, and again, at page 264, and it's also at page 504 of the appendix, the contract, the insurance contract provides, it limits carriers' liability to, quote, benefits required of the employer by the workers' compensation law, including any amendments in effect during the policy period. That is, the employer's obligation, the insurer's obligation is limited to those liabilities, those statutory responsibilities that employers have under the workers' compensation law during the policy period. There's no dispute in this case that these are one-year contracts that have a start date and a termination date.
Sure.
And we're talking about and so It is not true that either employers or insurance carriers by contract had any obligation under those contracts.
These documents to which you're referring us are not actually the contracts. Are the contracts in the record anywhere?
I believe that the state approved the form of the contract, and I believe that
The disclaimer at the front of these two documents you're pointing to at 503 and 263 of the record say, this quick reference is not part of the workers' compensation employer's liability policy and does not provide coverage. Refer to the workers' compensation and employer's liability policy itself for actual contractual provisions. So it seems to me you're asking us to invalidate state legislation on constitutional grounds because your contracts have been impaired and the contracts aren't in the record.
I believe that one of the affidavits in the case, and I could be wrong, that included these contracts, made a representation that these were the material terms of the contracts signed, the contracts issued during the prior policy periods. And I think there's no disagreement that this is in fact what the contracts are. The point is that under the contracts, the insurer with the state's approval, bargained for liability, indemnification liability for those obligations that the workers' compensation law placed on the employer during the policy period. And during those periods, Section 10 of the workers' compensation law.
Let me just stop you one second. The contract, forget about the amendments were made. When this contract was in place, it was coverage. Your employers who you contracted with assumed, and you assumed that you were able to transfer to the 25A account. When you lost the ability to do, and you did that pursuant to contract, you said, but that isn't included in the contract because the state wasn't a party to the contract. Now but nonetheless, the liability was calculated in the costs of the contract. That's the way I understand the facts in this case.
So,
Go ahead.
if I may, the word transfer in the statute is part of the 2013 amendment. The statute, Section 10 and Section 25A, at the time that these earlier contracts were enacted, provided in Section 10 that employers were responsible for disability compensation, quote, except as otherwise provided in Section 25A. And Section 25A stated that any award in a reopened case shall be against the reopened case fund, and therefore
So what is a reopened case? I mean, we've heard, and there are affidavits in the record about the difficulty and the amount of litigation in each and every individual case to determine whether, in fact, that was entitled to transfer to the fund, because it's not just a matter of meeting certain time frames. There were all sorts of issues that were being litigated about whether they qualified or not.
With respect, Judge Stein, there were two questions that when a claim was submitted to the Workers' Compensation Board, the board had to answer two questions as an initial matter. One, is this a claim that is made in a closed case? And two, if the case was closed, is it more than 77 years since the accident and 3 years since the last claim?
You would agree that those inquiries are not limited to just what the time periods are. There were all kinds of issues about what's a true closure, what's a payment of compensation, and what qualifies. I sat on the third department. I know the number of cases that got up to that court, and that doesn't even consider the ones that ended with the board.
The salient point for purposes of the constitutional analysis is that if it may or may not have been difficult in individual cases to determine whether something was a claim in a reopened case under 25A, but if it did, as this court explained in DeMayo, and as the third department has explained in many cases, liability for the indemnity payments passed as a matter of law to the fund. They were never the responsibility of the employer.
My point is that there's no way, as a matter of contract, to have anticipated exactly what those cases would be. I mean, so it's almost a term that is so ambiguous that it doesn't mean anything.
No, with respect, everybody was clear. There may have been factual determinations and factual disputes, but everybody was clear that as a matter of law, if it was a reopened case, there was no liability. The premiums that the state allowed the insurers to charge didn't cover it.
When you say everybody was clear, point to us in the contract where that was made clear explicitly.
Yes, well, the contract says, in the page that you cited, that the carrier's liability is limited to the benefits required of the employer by the workers' compensation law in effect during the policy period. And during the policy period,
And so you're saying
sections-
that exempts this fund then?
Absolutely.
Aren't you
I think
saying,
there's
though,
no
that-
dispute that it exempts
You could
this.
say to an employer, we're not paying this claim because we think that the fund should take it. And the fund says, we're not taking it.
The problem is, we're not arguing that under our contract with the employer has to pay this. The reason that we've had to reserve $62
Well,
million.
you're saying you don't have to pay it, and I'm asking you, what is it that you don't have to pay?
Are you
And
talking
how
about
do you
after
define
the
that?
amendment, after the amendment or
No,
before?
no, I'm talking about before the amendment. You're saying that there's a contractual right there to transfer these funds, these claims, to the fund. And so as a matter of contract between you and your insured, you are not responsible for those. But what are they that you're not responsible for? What if you think you're not responsible, and the fund thinks you are?
Judge Stein, we are responsible under those old contracts for any liability that the employer had during the relevant policy period under the workers' compensation law. Section 10 of the workers' compensation law provided that the employers had liability to make disability payments except as otherwise provided in Section 25A, which placed as a matter of law on the fund the indemnification obligation for reopened cases.
And a different way to read the includes any amendment language to which you've been pointing us is that there was a constant recognition by the insurers that the law might change any time, and they were assuming that risk.
The insurers were certainly assuming risks that the law might change and their indemnification obligations would change during the policy period. What the state wants to do is read out of the contract the words "in effect during the policy period." There's no dispute that the premiums that the state allowed us to charge for these periods took no account and could take no account either of indemnification responsibilities that would be covered by the fund under 25F or the assessments that we paid on an annual basis in order to pay those. If I may just spend
Can
one...
I ask, is there any cost that you bore that didn't get passed on to the employer pre this amendment?
You mean
related to
in the
reopened
assessments?
cases?
In the assessments?
To anything? Any attempt for a case to be reopened and to be transferred, shifted to the fund?
So any case, any costs, administrative costs that were involved in adjudicating a factual dispute, for example, that Judge Stein raised, were the responsibility of the insurers, and they were included in the loss cost calculations that the New York CERB made and the state approved in setting premium rates. Indemnification for claims under reopened cases was not included, and there was no compensation because although, as my friend points out, the statute in 25A3 says that, there'll be an annual assessment made to carriers for any shortfalls in the fund for cases pending. It also says that the insurers shall assess to the employers the amount of that fund. So we were a pass-through. Now, if I just...
Judge, could I just ask, I know his time is almost up, but can I ask about the taking clause arguments?
Yes.
Would that be all right? Just because we haven't gotten to that at all. I figured you might have wanted to get to that. So, just to clarify for me, I believe this court has decided that an economic regulation that merely imposes an obligation to pay money cannot be considered a taking. That's St. James, that may not be exactly in compliance with Supreme Court jurisprudence, but it seems that the Supreme Court has left the question open in Eastern Enterprises. I thought it was a plurality decision in Eastern Enterprises, and frankly, I'm not sure how it affects our jurisprudence right now. It may someday, but at this point, it doesn't. Do you agree with that?
So I can't.
Do you agree with the
if I-
principle that our jurisprudence, that New York's jurisprudence, says that an economic a regulation such as a tax that merely imposes an obligation to pay money cannot be considered a tax?
I agree with that as a matter not only of New York constitutional law, but federal constitutional law. What is at issue here is not just the obligation to pay money, but the diminution in value of existing contractual obligations that by virtue of a legislative alteration of the term of a pre-existing
See, in
contract.
some ways, I see it the same way you do in terms of I don't see this case so much as an impairment of contract, but rather an argument about the diminution in the value of the contract.
So it's an impairment of contract. I mean, the Supreme Court.
That's the question, isn't it really? Isn't the question really whether or not, if we're not changing a clause or adding a clause or modifying a clause in the actual contract, but we're saying that the contract may not be worth as much, just like if we raise taxes on your property may not be worth as much, or we change the zoning on it, or any other number of arguments. That's a diminution of value as opposed to an impairment of a contract.
Well, in this case, it's both, because an impairment of a contract is, in the retroactive sense of the word, anything that creates a new contractual obligation with respect to a contract that's already in place, as was in Hartnett. On the issue, just on the one factual issue that my friend mentioned, that this law was justified because, I don't know, after the 2007 closing of the Special Disability Fund, the insurers are making unanticipated use of this and sending off to this fund, or we're sending off to this fund, claims that otherwise would have been covered by that other fund, that it's important to focus on what is in the record in this case. The record in this case at page 259 and 260 demonstrates that between 2007 and 2013, the number of claims that insurers actually transferred to the fund decreased. It did not increase. There was an increase in the value of those claims and the amount that the fund had to pay out to those claims. But at page 260, the New York SERB shows that that was because of a vastly increasing rise in the rate of health care costs to the amount of 5% per year. Now, my friend says, well, over that period, assessments increased by by $300 million, and that
It
doesn't.
went from, I thought the number was 100 and something to 310.
Whatever it was, if you look, they're getting these figures from their declaration of Mr. Papa, the only declaration they filed in the district court. And those figures in his declaration refute this argument. What they show is that the actual costs to the fund over this period increased 7% a year, and we know that 5% of that was due to the rising costs in health care, while the fund increased
But does any
assessments
of
by
that-
26%
Does
a
any of
year.
that matter if it was always a pass-through to employers? You said before it was a pass-through, and it will continue to be one based on your argument that the DFS is going to raise the premiums to reflect going forward. So isn't the battle royale here only about this small number that are the past that are not going to get covered because the premiums
This
have
is
already been paid out?
the battle here, what you're calling a small number, is what the New York SERB estimated to be between $1.1 and $1.6 billion in unfunded
Your client's
mandates.
share is a much smaller
Our
number.
client's share, because our client's share of the business is much smaller, is $62 million.
How did you calculate that number?
We calculated it by the New York SERB used a methodology that complies with the New York State law that requires employers to raise their loss contingencies to cover to raise their reserves to the amount covered. And it's done in accordance with the standards required under, I believe, Section 103 of the relevant New York State statute. Nobody disputes that those numbers are right. In fact, the New York SERB and the Department of Financial Services have approved them. So there's no question that our unfunded mandate amounts to $62 million, and we have
So
reserved for
assuming the
that.
accuracy of that number, then how does that relate to the premiums or loss reserves that you have? How does it?
So it doesn't
relative.
relate to the premiums, because as a matter of New York law, and everybody agrees with this, the premiums that we're allowed to charge apply only to claims that may arise in the policy year in which the premium is assessed. So we cannot go back, and believe me, the Department of Financial Services wouldn't allow this. It would not allow us to basically say, well, we're going to have this unfunded liability. We'll make it up on the front end with premium payments.
Well, isn't that the nature of insurance? I mean, in some years, you made probably, a big profit on it, and then in other years, not so much. So
The question is what our contractual liability, or for purposes of the takings clause or the due process clause, our reasonable expectation was at the time. We contracted with the states, I think at the state's direction, but certainly with the state's approval, for a limitation on our liability, which is we are liable only for benefits that the employer has to pay during the policy period, not for any benefits that may have thereafter
would
increased.
you agree that your adversary said the special fund was set up for a very limited number of claims, and over the years, you've managed to expand what the initial intent was to begin with. How does that give you a right?
Judge Stein, I agree that in 1933, the number of cases that were these stale claims.
Well, let me just give you one example, okay? So when there were a few cases that came down in 2003, 2007, Jones and matter of Bates, that redefined, when authorization for symptomatic medical treatment was or was not compensation for purposes of determining whether this was a reopened case. And it seems to me that there was a practice that was engaged in by the insurance companies thereafter, which was, to have these indemnity-only agreements to sort of bypass that and let the cases continue to flow. So I guess part of what I'm seeing is that the insurers found ways to either increase or at least maintain the flow of cases that was not intended. And so just because you found a way to do that, how does that give you the right to have that expectation that it will continue?
The relevant question, particularly under the heightened scrutiny that's appropriate, that is applied for a contracts clause violation, is what the legislature's intent was, what its purpose was at the time. There is even the state, which is raising this argument in this court for the first time, supported by the statistics and the PAPA declaration that I've explained, says, oh, there was this practice that resulted in these vast increase in claims. Number one, the state isn't even saying this occurred. The state says in its brief that this may have occurred. What we know for a fact is that it did not occur, and that in any event, that is certainly not the legislative purpose. The legislative purpose was, as stated in the governor's approval memorandum, that the purpose of this legislation was preventing a windfall for carriers who don't need it because the premiums they've charged already cover this liability.
And saving New York businesses hundreds of millions of dollars in assessments, right? Wasn't that also one of the purposes?
What it says is it will save the employers hundreds of millions of dollars of assessments, which everybody agrees with. The reason that the insurance industry supported this law prospectively was that it was going to be vastly cheaper to simply have insurers adjudicate these claims rather than go through this long dispute about whose legal responsibility.
I know we're getting kind of long here, but
Last
you had
question.
Thank you, Judge. You had made reference to the standard being heightened here in the taking clause arguments. And my understanding is unless you've established a vested property right, for instance, here, the way I understand your argument, you'd have to say you had a vested property right and the law remaining the same, that there could be no alteration in the law or the legislative policy. Otherwise, my understanding is you got a rational basis test that has to be met, and it's obviously a much lower standard. You're arguing that there's some heightened standard in the absence of that vested property right in a particular law, which I've never seen. I don't see how you get there.
So, Judge Fahey, what I was referring to is the test under the Contracts Clause, which the Supreme Court
Okay,
has
not the
explained
Takings
in
Clause.
Gray and Connolly is intermediate
So
level
let me stop
scrutiny.
you. So I'm clear. It's not in the takings clause, it's in the contract clause you're talking about.
Yes, the Takings Clause is not rational basis either. Rational basis is the due process test for prospective application. This court has said in Chu versus the Alliance of Insurers that for retrospective application, the due process test is a multi-factor
I'm not sure, once
standard.
again, if Chu applies, that's the trust fund case, I believe, and, okay. All
I
right.
mean,
Thank you,
I-
Mr. Waxman.
Thank you.
Counsel?
Thank you. I'd like to make just three, hopefully brief points. The first is that Mr. Waxman argued that the effect of this statute is retroactive because it makes insurance carriers responsible for a new set of claims. But the critical point here is that on the date that this statute was enacted, and really the 9-month period afterwards, there were no identifiable set of claims that were precluded. The statute applies only to future applications. What this means is that if an insurer had a concrete reopened case for which it could apply for a transfer, it was able to do so for the 9-month period after the statute's enactment. And the only consequence of this statute was to prevent the transfer of cases that arise from reopened claims that would themselves reopen in the future. I mean, that is the very definition of a prospective legislation. The second argument that Mr. Waxman made was to say that the underlying liability here for reopened cases was not part of the original contract because the contract basically incorporated the fund's continued existence going forward. And there are a couple of problems with this argument. One is the one that Judge Stein pointed to, which is if it is true that the contracts themselves exclude liability, then it's a little unclear why the carriers care whether the fund remains in existence. They could just tell the employees or the employers, we're not going to cover that as a contractual matter. And if the fund also won't cover it, sort of that's your problem. Go back to the legislature. But the other point I want to make here is that this is a really sweeping argument to say that the contract freezes in place the law at the time that the contract was entered into. Because the workers' compensation law is enormously complex and includes, for instance, substantial both benefits and burdens on a wide class of the participants. And the argument that the contract prevents the legislature from changing those benefits going forward would basically preclude them from making substantial and important reforms. And one example is one that is raised by one of the amici to this case, which is the legislature's decision in 2006 to give 9/11 workers additional time to file workers' compensation claims. That reform was applied to injuries, by definition, injuries and policy years prior to that statute's enactment. Those sort of costs on the carriers were not part of their initial premium, and yet there has not been any challenge, nor do I think it would be successful to say the legislature was forbidden from enacting that change.
So do we don't have to decide the retroactivity if we determine that these other constitutional claims are without merit, correct?
That's correct. I mean, even if the statute
If we
had some
disagreed with you
retrospective-
on this matter.
That's correct. There's no particularly high bar to sustaining retroactive legislation. And the very last point I'd like to make is this. I mean, much of what the carriers have been arguing here is about the perceived practical burden of now having to retain these claims. Now, this argument about burden was not actually presented to the legislature at any time. Instead, the legislature had the unanimous support of the insurance industry and the employers here. But more to the point, to the extent that there is an ongoing burden that the legislature did not adequately consider, the proper forum for that complaint is the legislature itself. And this is not just an empty slogan to leave these questions to the legislature. The workers' compensation system is so complex that any change in one particular area has unforeseen consequences elsewhere. As Mr. Waxman referenced, part of the reason the fund became a problem after 2007 was that the legislature had closed a separate fund called the Special Disability Fund in 2007 that then led to the tripling of obligations.
But the reality is that moving forward, this is all going to pass through to the employers.
If this
And it
fund,
doesn't necessarily reduce the number of claims, right?
well, this will reduce the number of claims because it'll cut
Because
off
you're not going to get new
applications.
ones, but in terms of the ones that may be out there, they were either going to be reopened cases or they weren't.
That's correct. And the other important balancing act that the legislature did here was that it did not disturb claims that had already been transferred to the fund. The legislature could have decided, I suppose, to say that if a claim had previously been transferred, they were going to close the fund entirely and send it all back to the original carriers. They
Maybe
didn't
I
make that
misunderstood, but
judgment.
you're not saying it would pass through to the employers, it's going to pass through to the carriers on the reopened cases.
That's right. I guess I'd make this distinction, which is for claims that the fund
Well, no, but if you change
continues-
the premium, isn't his whole argument that it shows that the premiums never covered this because the premiums moving forward are going to cover this?
That's right. If I'm understanding the question correctly, it is true that to some extent the cost of these reopened claims going forward is going to fall back on the employers because of the increase in premium that DFS has approved. The legislature reasonably believed that the premiums would be lower than the cost of the assessments, in part because of the cost savings we referred to before, including no longer having to rely on this complex administrative process. But I think the fact that the fund remains in operation for previously transferred cases itself represents a form of balancing that the legislature engaged in. They understood that at the time that the Workers' Compensation Board had agreed to transfer certain cases to the fund, there might have been a legitimate expectation for carriers that they would not see those liabilities again. But
Thank
it
you,
was
counsel.
reasonable to have a different judgment for future applications.
Thank you.
Thank you.